compelled plaintiff to issue a formal, public retraction and to request his followers to cease all harassment and threats directed at Mr. Jackson Fannin. 4. Formally reprimand Mr. Chiappetta and issue an order directing him to control his client's conduct, as required by Rule 428.4 d of the Florida Rules Professional Conduct. 5. Award GPS all attorneys' fees and costs incurred in connection with preparing and filing this motion. Order that any violation of the court's order would result in dismissal of plaintiff's case. And 7. Any additional relief that the court believes is just and proper to address the issues raised herein. Docket number 334, page 23. The court has no authority to issue sanctions against Nishirvan under F. 1927 because Section 1927 only applies to attorneys or persons admitted to conduct cases in a court of law. Smith v. Grand Bank and 2, a FLA, number 04-80343, 2005 WI 6106148, at 7, SD FLA APR 28, 2005, collecting cases. See also Road was EXP, Incorporated, v. Piper, 447 U.S. 752, 757, 1980, stating that Section 1927 deals only with attorney conduct. Nor can the court sanction Chiappetta under Section 1927 because, even though he is an attorney subject to Section 1927, his conduct here is not sufficient to warrant such sanctions. See Peer, 606 F. 3D at 1314, holding that even though attorney acted in bad faith, sanctions under Section 1927 were inappropriate because the bad faith conduct was not dilatory nor did it multiply the proceedings. Even if Chiappetta acted with objective bad faith, GPS failed to substantively argue or show that the conduct was dilatory or that it multiplied the proceedings. Sanctions are appropriate against Nishirvan, however, under the court's inherent powers. First, Nishirvan interrupted deposition in which he was not a participant, telling Jackson Fannin he'd remember this shit at settlement. H. Nishirvan Dep 118 hours, and 20 minutes 21, when Jackson Fannin attempted to continue with the deposition. Nishirvan interrupted for a second time and called Jackson Fannin motherfucker, a dumb shit, and misogynistic piece of shit. I'd at 119 hours, and 10 minutes 12, 14 16, 24. Nishirvan crudely asked Jackson Fannin what the fuck was wrong with him. I'd at 119, 1920, fuck you were Nishirvan's parting words. I'd at 119 hours, and 24 minutes. Nishirvan's interruption and language at the deposition show subjective bad faith and merit sanctions, e.g. Thomas v. Tenneco Packaging Company, 293 F. 3D 1306, 1320, 11th 2002. A party also demonstrates bad faith by delaying or disrupting the litigation. Nishirvan repeatedly hurled expletives at Jackson Fannin, even after being told to stop, which establishes that his behavior was intentional and was so egregious that it could only have been committed in bad faith. Such misbehavior at a deposition justifies sanctions. Additionally, and more importantly, Nishirvan's conduct after the deposition merits sanctions under the court's inherent power.